Good afternoon. And again, for the afternoon session, for the folks who were not with us this morning, let me reintroduce the panel. To my right is Judge John Campbell from Germantown, Tennessee, the Western Division. To my left is Judge Tom Greenholtz from Chattanooga, Tennessee, the Eastern Division. And my name is Judge Camille McMullen, and I too am from Memphis, the Western Division. Each party has 20 minutes per side. Depending on what side you're on, you can reserve 5 minutes or whatever amount of rebuttal time you like. Just let us know so we can kind of keep up with that. Also pay attention to the lighting system because it's also tracking your time. Madam Clerk, let's call the next case.
We have some preliminary matters.
Okay.
For State of Tennessee, Casey Lee Anderson versus State of Tennessee, we had a notice of appearance filed.
All right. The person who filed the notice of appearance and the attorney of record, can you please approach the well? All right, I'd like to hear from the attorney of record.
Yes, Your Honor.
Could you approach?
Yes, Your Honor.
And could you state your name for me again? Is it Miss Adams?
Yes, Elizabeth Adams, Your Honor.
All right. Welcome. Welcome.
you.
I understand that there is some activity, some late activity in this case.
Well, yes, Your Honor. Mr. Dowd is a member of my firm, and we've been working on this case together for the past year and a half.
All right.
And I was originally appointed at the trial court, and then, of course, my appointment rolled over into the appellate court and filed a notice of appearance as co-counsel for Mr. Dowd yesterday, but the brief was written, has both of us on the brief, and he was participated in the post-conviction trial back in December of 2023 as well.
Okay. Miss Hornsby. Is it Miss Hornsby?
Yes.
I'm sorry. I'll get you in a minute. Ms. Adams, can you give us a reason why it was filed so late? I'm not sure you're aware of how we work. As you heard in the introductions, Judge Campbell is from Germantown, Tennessee, and that's about 6 hours away. I'm from Memphis, which is obviously 6 hours away, and we were en route yesterday when we got a call that a motion had been filed in this case, or a notice of appearance had been filed in this case. Can you give us a reason why it wasn't filed earlier? Do you know?
Honestly, Your Honors, we've worked on the case together. We're a two-person firm. We work on a lot of our cases together, and it didn't register to me that I would need to file a formal notice of appearance as Mr. Dowd for co-counsel because our trial work, we've done that together, and the brief as well. So just being in trial, we don't typically, would have to do that. We would substitute in for each other, and with our busy caseloads, we sat down, and Mr. Dowd was prepared to do the oral argument, and so then yesterday, let me file a notice of appearance as co-counsel for him, just as a formality, Your Honor. I quite honestly didn't know that that would need to be done with him being a member of my firm and having already assisted in Mr. Anderson's case.
Okay, well, we are only operating on who is, I guess, counsel of record, and that, I believe, is you, correct?
I was appointed, yes, by the trial court, so yes.
Okay, is that not counsel of record? Is that not the same thing?
It is, Your Honor, but I would submit to the court that Mr. Dowd would allow to be able to enter an appearance as a co-counsel for formality's sake.
Okay.
He's certainly helped me in representing Mr. Anderson now, like I said, for probably the past year and a half.
Okay, do we have any indication that Mr. Anderson is aware of what happened yesterday, meaning the notice of appearance?
I spoke with Mr. Anderson on the phone, and he was aware that Mr. Dowd was going to do the oral argument. We've all had meetings together, Your Honors. We were together when he was in Bledsoe County, actually physically last December, and Mr. Dowd's actually had several conversations with Mr. Anderson over the phone because of where he's at and the prison he's at.
So what is Mr. Anderson's understanding of who is to argue the case today?
That Mr. Dowd would be arguing the case.
All right. So I just want to express, and I'm going to allow my colleagues to address the situation as well, just how uncomfortable I was with getting a call while I was on the road that something had been filed on a case that had been set over a month ago. This court is now really being gracious in contacting counsel to determine whether the date that we select is a good date, because we travel statewide and we do a lot, as you can see, to prepare for these cases. So it was unsettling to, number one, have to get something, regardless of whether you believe it was just an informality, at the 11th hour on a case like this. So, just for future reference, probably need to pay closer attention, to how you're handling your matters in this court. We do not make decisions without a lot of thought. That's really what the appellate courts are for. We're not trial courts. We don't make knee-jerk decisions on much of anything. So just keep that in mind if you continue to practice before this court. And I'll allow Judge Campbell and Judge Greenholtz to weigh in, and then we'll make the determination of whether we will allow the substitution of counsel and argument by Mr. Dowd.
And I apologize.
No, and I think that what gave us concern, obviously, is I couldn't even look at any of the filings until I got to the hotel after 5. It was like 5:30. So by then it was so late. But just to articulate in the filing, the reason, the connection, because we really didn't have any information to go on as far as the relationship. Your client had been consulted about it, and the relationship with co-counsel. It gave us concern that your client wasn't aware of this and was going to get surprised by who actually argued the case. And so without any information, it makes it really hard for us to I think, come up with a reasonable ruling on your motion.
I think if I have any concern, is that there's not a representation in the record that the defendant agrees to it. So I have your representation in open court, you're an officer of the court. I'll take that as gospel in the absence of anything else. But if I'm asked later, there's not a single filing that says that Mr. Anderson was made aware of the change. There's not a single filing that says he understands why his appointed counsel is not arguing the case. As of right now, I don't know that there is a substitution. What I saw yesterday was a notice of appearance of someone else in the same law firm. Obviously, under Rule 13, he can't bill for the time. Right. That only goes to you. Mm-hmm. But I haven't even yet seen a motion to substitute an oral argument. And I think that if you're making that here orally today, that may be the first I've heard of it. That bothers me, frankly, because if I'm representing an accused, or if I am the accused, I think I would have concerns that my lawyer was not handling my case well, that it passed it off to another lawyer. And I know Mr. Dowd. I don't have any concerns with his ability to argue well in this case. It does concern me, though, that we have nothing in writing from your client. So has there been a formal motion that I've missed that is asking to substitute counsel oral argument?
No, Your Honor, I wasn't aware that I would need to file a motion to substitute.
You're the appointed counsel, though. We look to you when we look to the case. And so is that being made for the first time here at oral argument?
Yes.
What's the reason why?
Well, Mr. Dowd and I are in a two-person firm, and our trial schedules have been very difficult and heavy.
Are you prepared to argue today?
I can, Your Honor, yes, but Mr. Dowd had prepared to do the oral argument. We worked on the brief together. We did the post-conviction hearing together.
Okay, so you all have worked on it together, which means you've worked on it also.
Yes.
Back to Judge McMullen's question, if this were always the plan, why is the court only finding out that now we have a substitution on the minute of argument, frankly?
That's my fault, Your Honor. I just really, honestly, was not aware that I would need to file a formal motion with Mr. Dowd being a member of my firm and assisting me in representing Mr. Anderson. So I take complete responsibility for that, Your Honor.
Okay.
And I would
there-
have,
so
and
there's
I
not-
would have filed that.
Sure.
Yes,
And
I
So that I
apologize.
understand, there's no issue with you arguing today. There's no failure to be prepared, there's no illness, it's a convenience for the law firm is what it is, it sounds like, but there's nothing else that would prevent you as the appointed lawyer from arguing Mr. Anderson's case?
Mr. Dowd has prepared for the oral argument, Your Honor, and has spent time over the weekend and yesterday preparing. But if the court does not allow him to do so, then I will certainly do that as well.
Okay, thank you, counsel.
This is one thing that I do want to stress to you, counsel. If you continue to practice before this court, there is literally nothing absent some sort of medical emergency that we will handle the day before or the day of argument. Everything we do is done well in advance. Your briefs are filed well in advance. You are notified of the argument date well in advance. I'm having a hard time getting around in my head that this just was an oversight on your part.
And I apologize, and it was. And next time, we will approach as far as being appointed as co-counsel in an appointed case of this nature, because this case has been very time-consuming. And Mr. Dowd stepped in and has been a great assistance to Mr. Anderson in this case.
Well,
and
you've
myself,
stressed
and I
appointed
apologize.
multiple times, and we do appreciate you accepting the appointment. I
We
don't
do.
want that to, go without recognition. We do. But in accepting the appointment, you have the same responsibilities as any other lawyer to this court. So anyway, okay, we're going to take a moment
Okay.
and confer. Just give us about 5 minutes.
Thank you for your time.
This court will be in recess.
Disclose favorable evidence rendered the petitioner's plea involuntary or unknowing, or in some way induced the plea. Second, the petitioner failed to establish a Brady violation because Ms. Lively's statement to law enforcement was immaterial, and there is no proof in the record that Ms. Willen ever made a statement.
Okay. I would like to, to me, the issues are in the inverse. Do we not first have to determine whether there was a Brady violation?
Not if Brady doesn't apply pre-plea, which is my argument. So if Brady has no application pre-plea, there cannot be a Brady violation at that point. So had Mr. Anderson gone to trial, I think, what the first question is whether or not Brady even applies in these circumstances. And the state's position is that it would not apply here. And
But
so
if there's no Brady violation, what difference does it make? Do we even have to get to that analysis? The Supreme Court hadn't really said anything regarding, they're alleging this is factual, exculpatory information. Now, you say it's really not, but what difference does it make if it doesn't qualify as Brady?
I see your point, Your Honor. I suppose it can kind of go either way.
Well, if we had
I was viewing it more as if it doesn't apply, then.
Well, if we had binding authority that says that Brady doesn't apply earlier than trial, that would be one thing, right? We don't have binding authority that says that, do we?
Not specifically,
Not in so
Your
many
Honor.
words, right?
Not
So-
explicitly.
So we would actually be reaching a holding that either the United States Supreme Court hasn't actually reached, has implied it very heavily, granted.
Yes.
And not a holding the Tennessee Supreme Court has actually reached, though it has implied it also.
Correct.
So we would actually be stepping out in front of an issue, right?
I suppose you could view it in that way. I would argue that if Brady doesn't apply at all, though, then I kind of would view it in the inverse of that, where if Brady has no application here, then considering whether or not there's a Brady violation is kind of stepping outside of what the issue is. Though to your point, I do understand that it can be viewed in that way, and I'm happy to address the issues.
Well, the reason it's important in this case,
separately.
and you've briefed them both, so I didn't mean to get you on the wrong track. You briefed both issues.
Correct,
So
yes.
I guess I was just trying to get to, you've got to have a Brady violation first. You don't have to agree that that's the approach to take. But did the post-conviction court engage in a full-on Brady analysis in this case?
Yes, Your Honor, it did.
All
And
right.
it found 2 separate Brady violations.
All right, does the state take issue with the post-conviction court's determination that withholding the actual statement, I understand that the substance was the same at the preliminary hearing, was a suppressed exculpatory statement?
I think it is not entirely clear from the record whether or not the state suppressed it. It appears that the prosecutor viewed it as Jenks material and told the defendant that, or the defense attorney, that they wouldn't turn it over until.
Well, is it not Jenks material?
I think it is. I think it could also arguably be considered Brady material.
Well, do we not have statements that contain both of those things all the time?
It does have both of those elements to it, Your Honor. But nonetheless, regardless of kind of these other elements of Brady, the statement here was certainly immaterial. The information in the statement was disclosed to the defense in multiple other forms, which this court has said in several cases is acceptable, and that it doesn't rise to the level of a Brady violation.
So I guess I'm just confused. Why are we arguing about application if you agree that the substance of the information at issue here, the witnesses, this is an eyewitness to the defendant shooting the victim in this case, the statement to law enforcement versus her testimony at the preliminary hearing, they are substantially the same.
Yes, yes, Your Honor.
And there's materially no difference except form.
Correct.
So, again, the defendant was on notice. He was present at the preliminary hearing, correct?
Yes.
He
He testified that he recalled that testimony.
So what did the post-conviction court hang its hat on as to why this was suppressed?
It is not entirely clear, Your Honor. It's clear that the statement itself was never actually turned over to the defense. So that much is clear.
Does the state contend that they were entitled to keep the information until the witness testified because they disclosed, I guess what the issue here is, the defense of others or self-defense is what
Correct.
the defense is claiming that was exculpatory.
Yes.
That information was disclosed.
That information was certainly disclosed.
that-
There is case law out of this court, and I believe the Tennessee Supreme Court, that would still have required disclosing the statement, I believe, but then at the same time,
When you say-
or found that it was quote-unquote suppressed, but still immaterial because it was a different form.
You're talking about disclosing the form of the statement, not
Yes,
its substance.
correct,
All right, the
yes.
form of the statement is not a Brady issue, though, right? It's the
I think-
substance of the information that's the Brady
Yes,
issue?
that is more the Brady issue here. And certainly here, I think there is some case law that still requires the specific form to be disclosed, but it
Is
would.
that included in your brief?
I don't recall whether or not I cited
Okay.
it because I didn't make an argument about whether or not it was suppressed. I relied primarily on the immateriality of the statement.
So
If
you're-
you would
so-
like, I can file supplemental authority.
I would.
Okay.
Let me just make sure I understand what you're saying. Are you saying that under Brady, the state would still have an obligation to disclose the form of a statement, even if the information contained in the statement was disclosed at the preliminary hearing, even if defense counsel actually interviewed the witness, even if the state at the plea hearing made the representation to the court, and even though the defendant knows about it, Brady still would require disclosure of the written form?
No, Your
Okay,
Honor.
all
So
right,
to
then
clarify my position on that, I do not believe Brady would require that. I do believe that there are Tennessee cases that have interpreted Brady to require that, or interpreted that type of requirement.
As required either Rule 20,
I
either
don't
like-
recall whether the cases were looking more specifically under Rule 16 or Brady. I may be
I mean, 'cause
mistaken
there's-
about that.
You're saying that the state would be required to, because these are witnesses that the state were potentially going to put on during trial. Clearly, this is what this prosecutor thought. This is going to be an eyewitness
Correct,
to
yes.
a homicide. And all the time, prosecutors don't want to hand over witnesses' written statement until after they've testified at trial.
Yes, and I think this is a slightly different than just a straight Jenks scenario
Sure.
because the victim specifically is, I believe her statement said something about, I think, thought he was going to kill us all. So it's not
Sure.
quite a straight Jenks scenario.
Well,
To your
that
points,
happens
though,
all the time, though, does it not?
Yes,
It happens
yes.
all the time, which is why prosecutors always say, hey, this is what I've got that could be Brady. We're not talking about impeachment material. We're talking about potentially factually exculpatory or facts that could demonstrate factual innocence, okay? They've got to turn that over, but they don't have to, under Jenks, turn over the entirety of a witness's statement, correct?
Correct.
Okay.
And they wouldn't have to turn over the Jenks material until trial, which I think is what this prosecutor was trying to do.
Absolutely.
And, certainly there's some debate on whether or not he needed to, but I don't think that's necessarily a determination that this court has to make, because regardless of any of that, the defendant was present at the preliminary hearing when this witness testified. He agreed that he heard her preliminary hearing. Both of his attorneys interviewed her, and both of them testified at the post-conviction hearing that there was, essentially that they learned nothing new from her statement. So there was nothing in this statement that would have materially changed it. And the defendant's claim that I believe the defendant said that it would have made an impact. But his bare assertion that it would have made an impact on his decision to plead guilty is not enough to show that it would have been material in any way.
Was the statement also disclosed in the prosecutor's statement of facts at the plea colloquy?
Yes, so there were several times. The prosecutor explained during the plea colloquy that he anticipated Ms. Lively would testify, essentially corroborating the defendant's self-defense claim and defense of others. The existence of the statement was disclosed during the preliminary hearing because the prosecutor cross-examined her about some inconsistencies with the statement, but all of those inconsistencies had to do with kind of tension between the defendant and the victim beforehand, and then the actions that they took afterwards. None of the differences occurred when, during her account of the shooting itself. So for those reasons, it certainly isn't a material statement and cannot be a Brady violation.
Is it the state's position that there is suppression, but that the statement's not material?
I would not concede that there's suppression. I don't think this court has to decide whether or not there was suppression. I think either way, I think that the interaction of Jenks and Brady and how that all is implicated in this case, I don't think is something that this court needs to reach because it is so clearly immaterial. And in regard to the other statements, to the extent the court, it's not clear what the post-conviction court was finding here. It noted in its order that there was no proof presented that Ms. Willen made a statement, although the defendant asserted that she had. But then it found that the state violated Brady to the extent that it failed to disclose any other witness statements. So to the extent that this is a finding of a separate Brady violation, the evidence certainly preponderates against that. It's the defendant's burden to show a Brady violation, and there's simply no evidence in the record that Ms. Willen ever made a statement. One of the defense attorneys thought that the state perhaps didn't know where she was. He had tried to contact her and failed to contact her. And both the petitioner and his attorneys acknowledged that they had never seen a statement from her. So to the extent that the court did find a Brady violation on that, that was certainly error. And then we would also, going back to the initial point about whether Brady applies, we would also argue that it was error for the court to even apply Brady in these situations. So I guess to your earlier questions, we're kind of arguing that there are two errors here. First, finding Brady. Second, even applying Brady in these instances.
My trouble was I didn't see, and maybe I'm just recalling, I've read a lot of records in preparation for argument. I didn't see in the order a true analysis of Brady, which, as you know, is pretty thorough, or requires a full-out analysis of several different factors. I saw more of a findings,
Yes.
findings, but no analysis. So I was just curious as to why that may have been.
I'm not sure, Your Honor. The order is not a model of clarity, I would say. The court did find a Brady violation, so despite not conducting a more thorough Brady analysis, it certainly did apply Brady to this situation and found a Brady violation, and both of those were error. It was error to both apply Brady here. As you noted, Justice Greenholz, the Supreme Court has not specifically addressed, though arguably Ruiz comes very close to addressing the issue. It has a secondary holding that the state did not have to disclose affirmative defense information, which would certainly be exculpatory.
That's not really the way I interpret Ruiz. I mean, it's a stretch to say that's a secondary holding. That they were specifically.
It is certainly cabined to the facts.
Yes.
Yes. So I would agree there, but
and none of the federal circuits have interpreted Ruiz in the way that you just attempted to.
Yes, and federal circuits have gone both ways, but this court has also placed itself on the side of interpreting Ruiz in that way in State v. Kibido, where it discussed that Brady, it discussed those cases very favorably and stated that Brady was never intended to apply to pretrial policing.
Kibido was more of an impeachment case rather than a factual exculpatory case.
It was a different type of case in dealing with preliminary hearings specifically, and then there was all of the issues with confrontation. So I recognize that it is a different kind of beast that we're dealing with there, but I think it does speak very favorably of these federal circuit cases that interpret Ruiz in this way. So I recognize that there are certainly valid arguments to be made on both sides, but at the end,
we're not saying that the state can withhold what you are or you're suggesting that Thibodeau says is that the state could withhold information in its possession that a defendant is factually innocent. And that's just untenable. There are so many problems with that proposition, which is why I think the U.S. Supreme Court has not weighed in on this. To say that it just has so many ramifications.
And I think a lot of those concerns are reached by other areas of law that it doesn't need to be a Brady issue, would be my response. I recognize those concerns are very, very serious concerns to hold. And, but I think in those instances, there are other avenues that defendants can take. For example, there's, State v. Crow, I believe is the case out of the Tennessee Supreme Court, where it discusses that if a plea is induced by the state's Brady violation, then the defendant would be able to withdraw the plea to correct manifest injustice. So I do think that there are other avenues through which a defendant could address those concerns and receive relief for those concerns. And I don't think that it's necessarily Brady that needs to cover those, would be. And
I understand your position, and your time has expired.
Yes, it is. Thank you, Your Honors.
Did you reserve? I'm sorry. We
Yes,
jumped
I
in.
did. I'll
Okay,
just-
we'll get your rebuttal.
whatever's
We'll get you your
reserved is
rebuttal.
fine.
Yes.
Thank you.
Mr. Dow.
May it please the Court. My name is Michael Dowd, and along with Ms. Adams, I represent Mr. Anderson in this matter, and I thank the Court's indulgence for allowing me to make this presentation. In this particular case, we see this no differently than your typical Brady violation. There is no new ground that should be posited here.
Not new ground.
Yeah, there might be some
I need
new
you to
law.
address why this is a suppressed statement, when, as early as the preliminary hearing, the defendant was made aware that this witness testified that he shot the victim after the victim basically pointed the gun at these eyewitnesses. So you clearly had a potential defense of a third person's or another, and then another self-defense question. That was put out very early on in this case.
It was.
So what is the difference between, the substance that the defense was made aware of as early as the preliminary hearing and the statement, which was, I agree, the physical statement that was given to law enforcement was not handed over until after the defendant pled guilty?
The distinction here is that things were left out. That's the problem.
What things?
The fact that the alleged victim, Mr. Smith, actually had the gun in his hand the entire time of the episode, which means he was a continuing threat. If Your Honor's...
So now we're getting into the minutia of how strong the self-defense would have been?
Well, it's not how strong it is, but remember, under Brady, it's when you... Under Brady, you are allowed to substitute, but only if the statements are substantially similar. That's why even in Brady, the court there said, no, you have to turn over the statement. Let's remember the facts of Brady. The defendant knew about the co-defendant, knew what the co-defendant had done, had access to the co-defendant. The only thing that the defendant, Brady, did not have of Mr. Boblet was the actual statement in which he said he was the only shooter. The Supreme Court, in its decision, said that statement still needs to be turned over, even though there's all this other access. And the reason for that is because the court recognized, and the progeny since Brady has recognized, prosecutors don't always say exactly what's in the statement. They put a spin on it. They make it favorable to themselves.
Let me stop you for a second, because looking at the proof that y'all put on during the hearing, the two attorneys, Harmon and Johnson, when they were asked about this statement, about the information that they had, both of them testified that there was really nothing new. There was nothing new in this statement that was supposedly withheld, that it didn't change really anything.
No, that's not what they testified. They testified that what came out at the preliminary hearing was not any different than their interview. They never got the statement.
No, I understand that, but
the statement actually didn't come out to us.
Talking about the content of the statement is what I'm talking about. Both of them said it didn't change anything. There was no material difference between what they were aware of and what was in the statement when they looked at the statement.
No, they never got the statement.
After they got a chance to look at it.
They never looked at it.
You're saying that
At the
they
hearing,
They never got the
to
statement.
this-
That's what I'm trying to
excuse me, you're saying today, even as of today, they've not seen the statement?
They, to my knowledge, have looked at the statement cursorily, but we actually asked for the statement on this appeal just a little over a year ago. They never saw it at all, and this is some 10 years after the plea. They never
Was it
saw
before,
the
was it
statement.
before the post-conviction court?
We had it before we came to the
Was
post.
it, is it in the record before the post-conviction court?
Yes, it is.
All right, so the lawyers would have seen it at that time, right?
Well, they were witnesses. I'm not sure whether they actually saw the exhibits that were actually posited to the post-conviction trial
Did you
court.
all ask?
I do not believe that they were ever asked whether they saw the statements.
Did you ask?
I did not.
Okay.
So,
The
but
other
what we
thing
have
was-
here, and here's what the
Let
problem.
me stop
No, of
for a
course.
second. They also indicated that they had talked to this woman, Lively, whatever her
Mm-hmm.
name was, and that she gave them no additional information that they didn't already have, and they didn't already hear during the preliminary hearing. All right? So,
Which is the problem, which is why Brady says that you're supposed to turn over the statement instead of relying upon other representations.
Okay, I still haven't heard why the preliminary hearing did not put the defendant on notice that he had a justifiable defense of another and self-defense claim, because that is the substance of the statement. The witness here, her actual statement to law enforcement, had a lot of what I would consider irrelevant information leading up to the actual shooting, okay? So I am looking, the actual shooting wasn't more than a few sentences, okay?
That's correct.
And so I am looking at, there's no significant difference between what this witness testified to at the preliminary hearing and what was, in a nutshell, in that statement that went to this information that's in question. So you said the gun being in his hand the entire time. What else?
Well, the fact is that the entirety of the whole event, the fact is you can have some information from a witness at a preliminary hearing or even interviewed in which they may tell a certain part of the story. They may forget certain things. But we have to understand what Brady stands for. Brady's not whether you're put on notice of having this information. It requires the prosecution and the state to give over that information. Whether Mr. Anderson was on notice and his attorneys were on notice that there was a potential defense, that's not Brady.
But Brady doesn't require a specific format that the information be given, okay? There's no question that there was an exchange between the prosecutor and defense counsel. I mean, it wasn't you, but about this statement, there's no question that this prosecutor knew that there was information that he had or she had to turn over because it went to the defense, and the other information they did not, under Jinx, have to turn over. So I'm trying to get you to tell me, this is not a notice question, I understand what Brady says. I'm trying to get you to tell me what's the significant material difference between the preliminary hearing information and this statement.
The significant material difference is the fact that the prosecution during the post-conviction hearing, as well as during the statement during the plea by the prosecutor, as well as during the preliminary hearing, was that essentially the self-defense or defense of others was negated as a result of how many shots were fired. The fact is that if the person has the gun in their hand the entire time, you are allowed to keep firing. I'm unaware of any law in the state of Tennessee.
You're going to a different question,
No,
because that is why, from what I understand in the record, that is why there was some discussion about whether the self-defense would have been viable, because he shot the victim 20 times.
With different guns.
Yeah, with different guns. So that's not what we're talking about.
I believe, though, that it is when you go to the materiality prong. The fact is that we have to go back again to Brady. Again, as you stated, we're not talking about notice. This is a failure to turn over information that is exculpatory. As a prosecutor and under Brady and its progeny, you're not allowed to pick and choose what exculpatory information to turn over. You are to turn over all of it. And the fact is that was not done here.
Mr. Dow, what is the I think what the presiding judge is asking is, what is the information that was not disclosed that is contained in the statement, that wasn't in the preliminary hearing, that wasn't obtained as a result of the interview, that wasn't part of the plea colloquy, what is the information you believe is material? So I've got that a number of shots were fired.
No, my argument, Your Honor, is the fact that the person had the gun the entire time and was a continuing threat.
Okay, so
That
that's
is the
one piece of
significant
information, is
information.
that the victim in the case had the gun the entire time, was a continuing threat.
Right.
What else?
The other information that I would say that also plays a part in this, which I will now get to, is the fact that when an individual, and let's just say factually, believes that he acted in self-defense, defense of others, there's a difference.
I just need to know what's in the statement.
This-
What is the
I'm
fact
trying-
in the statement? So
The
I have
statement is
that
his
he had a gun.
understanding of who's there to back him up. And that is also important. That's another reason for Brady existing. If you are being told, as was brought out at the post-conviction hearing, both of his attorneys told him, if someone corroborated your story, we would have already had the statement. Therefore, I didn't get the statement. He's now standing alone.
All right,
That's
so
a
what we
far
have
cry
is
from knowing.
we have a disclosed witness who is examined in a preliminary hearing, who the lawyers talk to, who's the subject of the state's plea colloquy. He knows the witness exists. He knows what's going to be said, except for the fact that the victim had a gun and was a continuing threat. All right, he might not know that. What else does he not know that he needs to know that rendered the plea involuntary?
Well, at this point in time, he also doesn't know about certain movements that she also testified to. The fact is
Did she
that
testify to, or is it in the statement?
they're in both. And the fact
Right.
is they are
Okay.
somewhat different. And as counsel pointed out, when you actually look at the prelim transcript, there are some discrepancies there. Not having that statement ahead of time also did not
Can you
allow
help
for
me
effective
identify,
processing.
can you help me isolate what is in the written statement that is not otherwise disclosed?
Certainly.
Can you help me with that, please?
The way the statement works is it actually goes into a lot more detail as to the movements of the individuals as they were within that camper, and also the exit outside of the camper. That kind of detail did not come out at the preliminary hearing, also did not come out during the plea colloquy that the prosecutor put out, which would have allowed for more effective cross-examination to actually bolster the self-defense as well as the defense of others claim.
And so
Also-
with respect to that information, do we have a record that would allow the post-conviction court to find that the absence of that information rendered the plea involuntary?
The court could have in fact done that, yes.
Did
That
it
is-
find it?
The court did not find anything about involuntariness in this particular error. All the court found here in the lower court was that there was a due process violation because it found that Brady was in fact a due process case, which of course we all know it is.
Okay. What else was in the statement that you believe had not been disclosed previously?
The other thing that was not in there that was of some concern that I think would get in front of the court is the fact of the, how can I say this, the animus that was described in the statement. That also did not come out at the preliminary hearing as well as the post-colloquy for the plea, meaning that in her statement, there were statements made that would indicate why Mr. Smith would pull a gun on Mr. Anderson, and that did not come out in either of the other two events. And that is also important because that would give a motive for why Mr. Smith would be the aggressor, which again goes towards the materiality of the defenses. If in fact Mr. Smith in the statement, essentially there was a discussion in the statement between Mr. Anderson and with Mr. Smith in which Mr. Anderson believed that Mr. Smith was attempting to steal something, at which time Mr. Smith made some statements that basically were somewhat derogatory and somewhat threatful to Mr. Anderson, which would then show why Mr. Smith would then pull a gun and would then be a threat towards Mr. Anderson. That did not come out in any of those other two as well.
Are there other facts? So I've got three main differences here. One, that the victim had the gun the entire time, was a continuing threat. Two, there is more detail about the movements of the individuals outside. Three, there is more detail about the animus.
Well, not just, if I may stop you there, not just movements outside, but within the camper
Okay,
and then
inside
also
and
going
outside.
outside.
In fact, yeah, that's, thank you for that. And then we have more detail in the description of the animus providing a motive.
That's correct.
Anything else?
No, I would rest on that, Your Honor. As we all know, Brady doesn't require a certain number of factors in order for materiality to apply. In this regard, I would also say that Ruiz is not applicable here. The Supreme Court has always made a slight distinction since Ruiz, and even started before that, between impeachment favorable evidence and exculpatory favorable evidence. Ruiz is an impeachment case. I would also point out that one of the factors that Judge Breyer, or Justice Breyer, my apologies, stated in that particular case as to why they ruled that way is that in that plea bargain, it was a fast-track federal plea. And in a fast-track federal plea, the defendant is required to waive certain rights, including the right to get certain information from the prosecution. And Justice Breyer hinged that as one of his main 4 points as to why, in this particular case, getting the impeachment evidence prior to trial was not warranted. I would also suggest that the 4 circuits, the 1st, 2nd, 4th, and 5th of the federal circuits that have kind of tried to, I would say, unauthorized constriction of Brady to then say that Brady somehow does not apply at pretrial is unwarranted, in that they have failed to see the distinction between those 2 areas of favorability. I would call the court's attention to Brady itself. Brady does not say exculpatory. Brady uses the word favorable. What the court has done since then has gone in 2 different tracks to some extent that mirror each other. Impeachment on one side and exculpatory on the other. We don't have, this is not impeachment here. This is exculpatory. The fact that it's a statement doesn't make it impeachment material, though it potentially can be. It is exculpatory evidence. You have an eyewitness. My apologies.
No, I'm cutting you off, so my apologies. The problem that I have goes a little bit to what General Hornsby was discussing earlier, and that is, this really is a defense. This is a defense. So it's not, Ruiz talked about affirmative defenses, and granted, there's a difference between affirmative and general defenses, like self-defense. But the defendant was well aware of these facts. So I guess I'm having trouble getting into wrapping this around my head. These are things that he was aware of. So to, penalize the state for a defense that he was well aware of seems counterintuitive. You see what I'm saying?
I understand exactly what you're saying, and I would then say if that we were to take the state's position, then Brady wouldn't exist. Because the defendant in Brady knew about Boblet, knew what he had done, knew all the facts, had the availability to talk to him, did in fact interview him. All he did not have was the actual statement from Boblet to law enforcement, and the U.S. Supreme Court said, no, that statement needs to be turned over. Whether you know you have a defense or whether you know about certain facts is not the point. The point is that we're talking about justice. And the point is that
we're talking about in a case that there's a reasonable probability of a different outcome, right?
Actually, I would slightly disagree with that because that's not what Justice Blackmun actually said.
Let me take issue with that. There are lots of cases, and maybe you're putting all those into the impeachment context and maybe not in exculpatory evidence context. If you're incorrect about the distinction that you're drawing, what evidence is there in this record that disclosure of the physical statement to your client would have probably resulted in a different outcome? Is there any evidence here of that?
Yes.
What is it?
I would first of all say that Justice Blackmun in United States v. Bagley did not word materiality in quite that fashion. I know there's a number of courts that
that's fine. I'm trying to figure out what the evidence in the record is so that we can eliminate the issue or we can include the issue. Is there evidence in this record that had the statement been disclosed that he would not have pled guilty or that he would have pled guilty to a different charge?
Yes.
All right. What is the evidence?
The evidence would have been that by showing a motive on the part of Smith to actually shoot Mr. Anderson, then producing a gun, continuing to have the gun through the entire altercation, would in fact justify, and having a threat to 3 people in that trailer, would in fact prompt a reasonable person under the laws of the state of Tennessee to believe that they can act in self-defense.
Did your client testifies to that at the post-conviction hearing?
The fact is he did testify to that.
He said that he would not have taken the plea had he seen the actual statement?
He most certainly did, Your Honor.
Okay. Did the post-conviction court make a finding to that effect?
I believe that in their findings they did point to that, yes. I believe it's in error number 4, if I'm
They
right.
pointed to it. Did the post-conviction court make a finding to that effect?
I believe it was in finding number 4, Your Honor.
Okay.
Yes, he actually did testify to that, and it is found in the record, and I believe that the lower court did in fact cite to that.
Okay, finding number 4.
Yes, and don't quote me on that, please. I think it is
I just
number 4.
did. I mean, you represented it here, so it's coming back.
It's either 3 or 4, right around there. My numbers in my old age start to jumble together.
Fair enough.
The fact is, though, is that the materiality prong, as enunciated by Justice Blackmun and Bagley, is whether the lack of disclosure undermines the confidence in the result or the outcome, not whether it's going to change what happened.
I mean, we can play those games all day. I mean, we've got the Tennessee Supreme Court in Johnson saying evidence is deemed to be material when there's a reasonable probability that had the evidence been disclosed to the defense, the result of the proceedings would have been different.
And
I mean, that language appears in our cases. So,
And I understand that, Your Honor. I'm not here trying to play games with anybody. A man's life is at stake. The fact is that all I'm trying to do is make sure the record is correct. I understand what the state of Tennessee has said in its Supreme Court, but I would also understand that it's the United States Supreme Court, unfortunately or
so
fortunately.
the Tennessee
is
Supreme Court has been applying the wrong standard since 2001.
I think what they've done is they followed along with a lot of other cases who have sort of summarized, and I'm sorry to say that.
You think we need to correct the Tennessee Supreme Court?
I do not think that you have the authority to do that, Your Honor.
All right.
But in this particular matter, Your Honor, we do in fact have a suppression. We do in fact have favorable evidence. We do have materiality. The fact is here is that an individual was deprived of a statement that not only corroborated what he had to say, but also added additional details to it. And I see that my time is up, and I thank the court.
Thank you so much. General Hornsby.
Thank you, Your Honor. First, just a couple factual clarifications. Ms. Lively testified at the preliminary hearing that Mr. Smith had the gun in his hand as he went out the door. So that is not a difference between the statement and the preliminary hearing testimony that came out at the preliminary hearing. She didn't see anything once he was outside the door because she stayed in the camper, kind of huddled down with Miss Willen. Similarly, Mr. Harmon testified that the statement was pretty similar to to his interview with Ms. Lively and to the testimony. So I think we can infer from that he had seen the statement at some point, either during or before the post-conviction hearing. I don't believe there's testimony explicitly saying how closely they looked at it. I might be wrong about that.
Well, the point is that no one asked.
No one, either no one asked, or you can, certainly infer that they had seen it because they both testified about what was in the statement.
Didn't they, my reading of it, both of them said that it really didn't make any difference.
They did both say that, yes. That there was no new information from it. The statement wouldn't really make any difference. And to counsel's point about the additional details, certainly the statement is more detailed about the actions, again, before and after the shooting. But the core facts of the shooting, that Mr. Smith pointed a gun at the defendant and both women, he backed out of the camper holding a gun, those are the core facts supporting his self-defense claim. And at the end of the day, the defendant knew that his self-defense claim and defense of others claim was supported. And that's another reason that his bare testimony at the post-conviction hearing that he would have chosen not to plead guilty if he'd known, or his own self-serving testimony about this is fairly easily discredited because one of his attorneys explicitly testified that he took what would have been a really great self-defense claim and made it a not great one. As to your point, Judge McMullen, he used 3 separate guns to shoot the victim out of the camper 20 sometimes. So again, it would have been
It's not up to
unreasonable.
us to credit or discredit the petitioner, though. Those are the findings that we rely upon the post-conviction court to make. Your friend on the other side suggests that the post-conviction court credited his testimony.
I know that the post-conviction court did point to that. I don't recall whether it explicitly credited that.
You all ask us all the time, and we do, so all the time implicitly credit testimony found by a trial court. So
Sure.
did the trial court implicitly credit testimony here?
It could be that the trial court, and I would argue in that case that it's a clearly erroneous finding. The evidence simply doesn't support that the defendant would have chosen to not plead guilty and would have gone to trial. Again, the only testimony about that was his own self-serving testimony. All other evidence in this record points to that pleading guilty was the best decision he could have made here. And, you know, to the extent that the court did implicitly credit that, I don't think it explicitly credited that testimony, but to the extent that it implicitly did, it was clearly erroneous. And so we would ask that this court reverse the judgment of the post-conviction court. If this court has no further questions. Thank you, Your Honors.
Thank you so much. The case will be taken under advisement. Call the next case.
State of Tennessee versus Charles